Form FL-820 finishes a California summary dissolution, but only for a joint petition filed before January 1, 2011. Here is who still needs this form, how it differs from FL-825, and how to fill it out. What is Form FL-820? Form FL-820, Request for Judgment, Judgment of Dissolution of Marriage, and Notice of Entry of Judgment, is a California Judicial Council form used in the summary dissolution process under Family Code Section 2403. It does two things in one document. It lets a spouse formally request that the court enter a judgment of dissolution, and it serves as the judgment and notice of entry once a judge signs it. The form was revised effective January 1, 2012, at which point it was limited to older cases only. For any joint petition for summary dissolution filed on or after January 1, 2011, the court uses a different, newer form instead. Who still needs FL-820 in 2026. The form states plainly that it should be used only if the joint petition for summary dissolution, Form FL-800, was filed before January 1, 2011. Because that cutoff is now more than 15 years in the past, FL-820 is relevant to a genuinely small group of people, those whose original joint petition was filed before 2011 and whose case, for whatever reason, was never finalized, was previously revoked, and needs revisiting, or is otherwise still open. If your joint petition for summary dissolution was filed more recently, and especially if you are starting a new summary dissolution case now, this is not the right form for your situation. FL-820 versus FL-825. Beyond the filing date cutoff, the two forms differ in a few practical ways. Because domestic partnership dissolution is not addressed on FL-820 at all, anyone using the summary dissolution procedure to end a domestic partnership needs FL-825 regardless of filing date. When you can file FL-820, FL-820 requires the court to confirm two things before a judgment can be entered: that the joint petition for summary dissolution was filed on a specific date, and that no notice of revocation has been filed and the parties have not reconciled. Either husband or wife can file this request with the court 6 months after the joint petition was filed, consistent with California's mandatory 6-month waiting period for dissolution cases. If a filing fee applies to your request and you cannot afford it, you may be able to request a waiver using Form FW001. Section-by-section walkthrough of FL-820. Here is what the form actually asks for. Caption and case information. At the top, you fill in the superior court and county, the case number, and the names of husband and wife. This should match your original joint petition for summary dissolution exactly. Filing date of FL-800. You state the date the joint petition for summary dissolution was filed. This is also where the form repeats the instruction to use FL-820 only if that date was before January 1, 2011. Confirmation of no revocation or reconciliation. You confirm that no notice of revocation has been filed and that you and your spouse have not become reconciled since filing. Request for entry of judgment. You request that the judgment of dissolution be entered either to be effective now or entered nunc pro tunc, meaning retroactively effective as of a specific earlier date for a stated reason. You then sign this section under penalty of perjury. Restoring a former name. If either spouse did not request that their former name be restored when they originally signed the joint petition, this section lets them request it now. You specify the former name and sign this section separately. The court's judgment, completed by the judge. This section is completed by the judicial officer. It orders that a judgment of dissolution of marriage be entered and that the parties are restored to the status of unmarried persons. Includes checkboxes for a nunc pro tunc entry date and for restoring either spouse's former name, and confirms that husband and wife must comply with any agreement attached to the petition. Notice of entry of judgment and clerk's certificate of mailing. On page 2, the clerk fills in the date the judgment of dissolution of marriage was entered and certifies that a copy was mailed first class to both husband and wife at the addresses listed on the form. Understanding the Nunc-Pro-Tunc request. Item 3 on FL-820 is one of the more confusing parts of the form for people filling it out on their own, mainly because of the Latin term Nunc-Pro-Tunc, which simply means now for then. In plain terms, it lets you ask the court to treat the judgment as if it had been entered on an earlier date than the date the judge actually signs it. This matters because a long delay between when a case became eligible for judgment and when the paperwork actually reaches a judge is common in older, long-pending cases, exactly like the ones that still rely on FL-820. What happens after the judge signs it? Once the judicial officer signs FL-820, a judgment of dissolution of marriage is entered and both spouses are restored to the status of unmarried persons. The form also carries a required notice. Dissolution can automatically cancel a spouse's rights under the other spouse's will, trust, retirement benefit plan, power of attorney, pay-on-death bank account, transfer-on-death vehicle registration, and joint tenancy survivorship rights. It does not automatically cancel rights as a beneficiary of the other spouse's life insurance policy. The notice recommends reviewing these documents, along with credit cards, other credit accounts, and credit reports, once the dissolution is final. Common mistakes to avoid: using FL-820 for a case where the original joint petition for summary dissolution was actually filed on or after January 1, 2011, when FL-825 is the correct form. Trying to use FL-820 for a domestic partnership dissolution, since the form only covers marriage. Filing before the 6-month waiting period from the original FL-800 filing date has actually passed. Forgetting to confirm that no notice of revocation was filed and that the spouses have not reconciled. Leaving item 4 blank when a former name restoration was intended, since the judge has nothing to order without it. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-820 for you. Virdix is a document preparation service, not a law firm. So this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.